A lawyer shall not reveal information relating to the representation of a client unless, stay with us, this is the law. It's your legal light, it's your help law. I'm Samson Ladia Yenini. We have the second installment of Punishing Lawyer Misconduct. We'll be right back.
When the person comes to you, he sees you as a god, another god for him. Now, the pedestal the person has placed you on, it will be demeaning to your own profession, your colleagues, to the law, for you to lower the standard and be dishonest to him. You have to be honest.
All right. So
honesty is the key.
Let me come to you out here. What I need you to do this for me. Pick at least one or two other rules and let's share with our audience.
Well, so I'll just choose one word: fiduciary.
Fiduciary.
Yes.
Duty to the client.
To the client.
Okay. What does that mean?
And it means that you are like a trustee. So that when, for example, the client's money has been paid to you, you owe him a duty to disclose and be transparent about it. Two, and it's something that I found out when I was doing research on some of these matters. Gifts. Before a lawyer accepts a gift from a client, especially a gift contained in a will, you must be very careful in accepting that gift. If possible, don't accept it, no matter how attractive, because you may end up breaching the fiduciary relationship, which is a very serious misconduct. And there have been a number of cases in which a lawyer's conduct has been, in accepting a gift from a client, has generally been ruled to be unethical. And for me, that, and also coupled with non-disclosure and those on integrity, should be something that we should continue to talk about. I mean, we also must be empathetic, because these rules are only taught at the last stages of your training as a lawyer at the Ghana School of Law, where within 6 months or 1 year, you are supposed to all of a sudden know all this and to live by it. And so we've made the case that they should actually be taught at the formative stages, probably even at the faculty, or at least the first year at the Ghana School of Law, so that by the time you get to the bar, and the continuing legal education should consistently be talking about this, because until I even started doing this, I didn't even have a copy of this rule. And I think a number of us as lawyers have taken it for granted.
Right.
And yet, that can lead to you...
And there are many too who are using our old rules.
Yes.
You don't know that they have changed this
Even
much.
the new one, which an interesting title, 2423.
That's right.
Which is so easy to remember anyway.
Yeah.
Please. So we will advise ourselves to grab copies and as much as possible, because no matter how competent you are, you may lose your profession that you have worked so hard for, because you may have overlooked or forgotten about these rules.
You're welcome back. This is the law. It's your legal light. It is your help law. I'm Samson Ladi Ayenini, and we're continuing the second installment of Punishing Lawyer Misconduct. I'm beginning on this note. On the 31st of January 2024, the General Legal Counsel Disciplinary Committee issued a notice or an announcement, and the entire media was awash with this notice discussing left, right, center. It says, disbarment of lawyer Samuel Nekwe Tete from legal practice. Notice is hereby giving that on the 23rd of November 2023, an order was made by the Disciplinary Committee of the General Legal Counsel, acting in pursuance of the provisions of Section 30 of the Legal Profession Act 1960, Act 32, as amended, and Regulation 20 of the Legal Profession Disciplinary Committee Rules 2020 LI 2424 that Samuel Nekwe Tete should be struck off the rule of lawyers in Ghana. The above-named lawyer was charged and convicted on one count under Rule 2.2 of the Legal Profession Professional Conduct and Etiquette Rules 1969, LI 613, as follows: that he, as lawyer and a chief state attorney, having acted as counsel for the state in the case entitled Alfred Agbesi Woyome versus Attorney General and another, had an amount of 400,000 Ghana cedis transferred directly from Mr. Alfred Agbesi Woyome into the bank account of his wife, Mrs. Gifty Nekwe Tete, on 16 June 2011, without any reasonable explanation. A conduct or act that adversely affects the dignity and high standing of the legal profession. Samuel Nekwe Tete shall not hold himself out as a lawyer or attend chambers or render or purport to render any professional legal services to the public. The practicing license of Nekwe Tete, Samuel Nekwe Tete, is hereby withdrawn forthwith. And what's the point? As my guest said the last time, these rules are new and replace the old rules. And even many lawyers, very many lawyers, are unaware of these new rules. So it is good that we share them, discuss them, so that you as a potential client and also our friends, lawyers, will get familiar with these rules. Otherwise, you get into trouble. Now, today too, we're privileged to have the two distinguished lawyers who joined us the other day once again. Musa Ahmed is head Ahmed Legal Consult. He's been very helpful to the law platform, and for the very first time, he's right here in the studio, gracing our new studios. So these are actually our very new studios.
It's amazing.
And also here is Berimaya Kodier Opong, who is Director, Ghana School of Law and Director, Legal Education. Thank you very much.
Thank you very much. You know, the last time our brother was still preparing for the final stages of his brother's
yes, that's
transition
right. That's
to God.
Right. That's right.
Yeah, so I was amazed that he still found time to
that's true.
Communicate with us. Today he's here.
That's another duty of a lawyer.
Yes.
That's another duty of a lawyer.
Yeah, he was so composed that I told him there's something about Islam in terms of death that they are able to endure it better than I would have as a Christian.
Right.
And there's a lot to learn. There's a lot to learn from them.
Everybody envies the way they do it as Muslims.
There's a lot to learn from them.
There's too much waste associated with the other forms of doing it.
I know. One day maybe you can engage him.
Right.
Shall come to pass.
Okay. And the last time, if you remember, we did our Law 101 on the fourfold duties of a lawyer: duty to the court, duty to your client, duty to the profession, and duty to the public. And Musa Ahmed made a revealing input, changing the duty to the court almost literally to duty to the law. And many were really impressed by that. Yeah. So let's get on to it. Now, today, we are dealing with various aspects of the provision that the law that we have been sharing with you. And I'm going to begin with Musa Ahmed. First, we'd like a brief comment on this particular provision of the law from the both of you before we go to the aspects that you yourselves want to spend time discussing. And that is Rule 16.1 and 16.3. Rule 16.1 and 16.3 say, a lawyer shall not make an agreement for, charge or collect an unreasonable fee or an unreasonable amount for expenses. A lawyer shall communicate in writing the scope of the representation and the basis or rates of the fee and expenses for which the client is responsible to the client before or within a reasonable time after commencing the representation. So you have it on your screens. A lawyer shall not make an agreement for, charge or collect an unreasonable fee or an unreasonable amount for expenses. We begin with this because many who have gotten to us and have commented on part 1 have been asking that you didn't talk about legal fees. We are interested in that. Yes. So, yeah. What do you say?
Well, thank you. And me underscoring this is the fact that the legal profession is a business. It's a venture. And the law recognizes that. That is why it says that, and consistent with Proverbs, the laborer is entitled to his due.
Worthy of his wages.
Yes, worthy of his wages. Interestingly, there is a competing interest. And you know that at the beginning of the profession, many years ago, a lawyer was not, for the first instance, entitled to be paid.
You are taking us back to your priestly, analogy.
That is why it is called, it is a calling.
Right.
It's a profession. So that's why some ask, when you wear your gown, and there's this long rope with a small pouch, they ask, what is it pouch for? And the understanding is that years ago, it was not legitimate for a lawyer to be paid, at least, not openly. So they will put the coins through the long rope and it will fall into the small pouch. So please, when you go to court with your lawyer, you will see that there's a small pouch like
Don't
this.
go dragging your lawyers. Don't go dragging the rope on your lawyer's gown and dropping coins in it.
So the point is that originally the objective is not to render legal service for fees. But over the time, we have acknowledged the fact that it's a business. And the law has prescribed strictly how that business is to be rendered. And the fees for the business is not even only how much to be taken, but how it should even be taken. And that is why there have been a number of cases where when a lawyer has not specifically entered into an agreement with a client, the case is ended, he sends a bill, and the court says no. From the beginning, you did not even tell him that this is how much, this Tamaklo case. A lot of people don't agree anyway. This is how much I will charge you. Or even when you have charged the person, you should give him prior notice that pay this amount, which we have agreed. Otherwise, I will take you to court. So not even giving a notice to your own client who has agreed with you that this is how much I'll pay you. And it is also one profession that it's not about if you win, I pay you. I mean, it's strictly about I perform a service, you pay me whether I win or not.
But people can do a mixture of the fees.
Well,
they can do an upfront payment plus after suit success.
Yes, every installment payment is all right. So the point I'm making is that sometimes the rules make it seem as if this is a profession that makes people perform a service without expectation of remuneration. But at the same time, the second aspect is that it is also a business, it's a venture. And so when I have people, I remember a friend telling me, you know, all the laws in Ghana, even though I didn't think he was right, but the only law you don't know is the law of charging. And I had the opportunity to speak to a lawyer in London, and by the time I was leaving his office, he told me I was owing him £50. But you can't do it in our system. So these rules must be interpreted consistent and reflective of the people we live in Ghana. you can get someone to come.
There's something known as overestimation of fees, which can lead you to lose your license. And there's also something known as underestimation of fees, which can lead you to lose your license.
But the under one, I have never heard of anybody.
The underestimation.
Anybody, but the over one, I have had occasion to hear.
So when Rule 16.1 says,
Yes.
a lawyer shall not make an agreement for or charge or collect an unreasonable fee or an unreasonable amount for expense. What does that mean?
Some say if you were to follow strictly these rules, a lot of Ghanaians cannot access legal service.
That's right.
And that is the truth. I mean, elsewhere. And my friends think that, like we sitting here talking about law, I'm even charging this institution. And then they think that that's how I make my money. When I used to come to news file,
right.
So, but that's for you. When we are complaining, you shouldn't, because all these consultancy you are giving to Joy FM. I said, well,
because that's what it should be.
Yes. And I said, no, I don't charge. It's public service. And they don't even believe it.
I work with a law firm, and a media house retained the law firm. And when they are going to do their normal programming, their news, their morning shows, and things come up, they call lawyers in the law firm to ask questions. When they called, they got bailed.
Yes, your time.
And when they were told that you have been bailed, you are supposed to pay X amount of money, they said, but how did that bill come about? I said, you've forgotten you have called us how many times to ask us to clarify something for you before you go to the news?
So we have fine rules, some of which, when they benefit the lawyer, he can never enforce it. But when it's against the lawyer, they can easily be enforced. And I think we need to find a balance between that. A lot of lawyers are doing free work where they should have charged. In Ghana, until you take a case to court, the ordinary person who has come to lay your tiles and has charged you per the hour or square meter doesn't see why he should even pay you as a lawyer. Oh, boss, my landlord has thrown my things out. After he has charged you for every square meter that he has charged, he doesn't think that the advice you are giving him is worth any charging. You understand? So we need to look at these rules and see the business aspect of it, and also the fact that, yes, we are also called upon to render service without claiming any due, and merge it. And when these matters come up, the general public should understand that we have, as lawyers, we have rendered
Thank you. What we will
service
do
as
is that we'll find time and do just fees and charge it separately, so that you can, because it's such a broad topic, we can't deal with it now. So we just want gist of it. For those of you who have sent so many messages and insist that you want us to discuss it, in the course of this show, when we open, I'm bringing you in. When we open the phone lines, you can ask questions about fees, and we shall answer them. Now, Musa Ahmed, it says that for the purposes of this, a lawyer shall, for the purposes of determining the reasonableness or otherwise of a fee, take into consideration the following: 1, time and labor required in the work that you are going to do, the novelty and difficulty of the questions involved, and the skills requisite to perform the legal service, the likelihood, if apparent to the client, that the acceptance of the particular employment shall preclude other employment by the lawyer. You're taking a case and you cannot take some other cases because you've taken that case. All of that will go into the fee. The fee customarily charged in the country for the provision of similar legal services. This will be referring to our scale of fees. Yeah. An amount involved and the results obtained. What you are going to do, how much is involved, and when you get it, maybe the lawyer will get you some millions of dollars, so it can influence how much he charges you. The time limitations imposed by the client or by the circumstances, the nature and length of the professional relationship with the client, the experience, reputation, and ability of the lawyer performing the services, and whether the fee is fixed or contingent. And finally, whether the fee falls within the approved scale of fees.
Well, you see, I have always looked at the rules relating to fees from a different angle. My point is that, look, we already have general rules of contracts. If you look at the rule as is espoused in 16, I don't see it deviating substantially from the general rules of contract, because there has to be an offer, there has to be an acceptance, there has to be an intention to create legal relations, there has to be consideration. These are factors I'm sure they took into consideration. Specifically, bringing it down to the doorstep of a lawyer, it is because our profession is seen as a specialized profession or institution, if you like. So therefore, we are not providing services that is of general nature. We are providing services for specific group of persons who require our services. So there is a need for them to regulate the conduct of the fees, how much you can charge. You have to take into consideration the nature of the work, the scale involved. All those factors too, I will call them, they are subjective.
Yeah. Okay.
Because you sit in your office, someone comes to give you a case on, let's say, matrimonial cause. Then within that space of time, you are able to determine that this case is going to be difficult for me. You don't have the evidence, you haven't confronted the other party's evidence. How are you going to determine that? Meanwhile, the rule is saying that you must determine the fee from the start. When you don't have all the factors before you, and as my brother vividly put it across, you see, if we want to adhere strictly to the rules, then the clients are going to be in difficulty. So what we do is that there are several factors. Most of our clients cannot read and write. We don't have, facilities are not available. Even the lawyer's office, certain key facilities are not available. We are supposed to ensure transparency, which is a very key element of the etiquette rules. We don't have the facilities.
But as part of transparency, now the scale of fees by the Ghana Bar Association is on Google. So clients can simply go and Google, and they will see it there. They will see that if you are doing an hourly service for them, every hour they are supposed to pay you 2,000 or 4,000, depending on your years at the bar.
That's right. But you see, how many Ghanaians can go?
I'm not sure you have ever applied.
I mean, how do I go to my village, tell my people that go and make reference on
Google?
I mean, that is an impossibility. So there are disabilities. Those disabilities, the profession, the makers of the rules must take into consideration. It appears that they have limited the rules to a few number of Ghanaians. I mean, they have neglected majority of Ghanaians who also are entitled by law to legal service.
But is it agreed that whether you are doing what we know as contingency fees, that's depending on what happens, the hourly rate or hourly fee that you are applying, the fixed fee, which in the scale of fees it is put there, that if you are doing this kind of case, you will pay between maybe 40,000 and 60,000 or so and so like that, flat rate. Then you have the consultation fee. Then I think I mentioned retainer. We also have the filing fees. Of course, that one is dictated by how much the court is going to be. You're going to pay in court for doing a particular thing, or what you call the court fees. Is it accepted or agreed per the last portion of this rule that once the fee goes beyond what the scale of fees provide for, then you have done overestimation of fees, and therefore it's misconduct, and you can lose your license. Like not too long ago, Francis Xavier's also suffered that he had charged the client more than he was supposed to charge, or the situation which is called underestimation of fees. You are destroying the profession by charging.
The bar must prosper.
The bar must prosper.
Sitting by the cocoa affairs, practicing from your car boots, and a bail application which would attract maybe about 20,000. You have charged only 20 Ghana cedis, so you are destroying the profession. Is it the case that it's agreed that once it is below the scale of fees, it's underestimation of fees? If it's above the scale of fees, it's overestimation of fees, and you could suffer a penalty for it?
You see, that's why I said initially that we should not simply remove the profession from the normal law of contract. You see, we talked about consideration. What is the value of the consideration? We cannot adhere strictly to this. If, for instance, I have a client who is known to me for many years, and I know him for, let's say, over a period of 20 years. Within that period, he's been of value to me in terms of assistance. He's given me several things that I cannot quantify in money. If he comes to me with his case, shouldn't I have the discretion to slash the fees for such a person? Shouldn't that be within the sphere of law of contracts, such that I have the right to determine what comes to me? Forget about the integrity aspect of it. You see, certain factors must be considered. So for me, we should have exceptions to the general rule. I agree that a lawyer should not simply undercharge, because when you do that, you undermine the integrity of the profession, you disrespect your other colleagues, you also undermine the works of your...
So as I said, if we are not careful, fees will take the whole of the time. That is not what we are doing today. So let's go again, because it can get a lawyer into problem. And many lawyers are in trouble because of fees.
Yes.
If you go to the General Legal Counsel's website, you see most of them is about fees.
They're mostly about the high one, not the low
one.
Anyway, okay, so you say these provisions are interesting and you would like us to speak about them.
Yes.
Acting for more than one party, Rule 22.
Yes.
What is it about?
Yes. You see, the whole of Rule 22 is about conflict of interest. You see, you typically in a criminal case where one transaction affects two accused persons, it will be improper for a lawyer to seek to represent two of the accused persons who have been charged from the same transaction. Now,
the law says a lawyer or the firm of a lawyer shall not act as a lawyer for two parties in the same transaction.
Yes, that's what I narrowed it to a criminal case, for instance. It does apply to civil cases, and I know there are exceptions. For instance, in mortgage cases, I know those ones you can do, depending on whether the conditions there exist. But the point is that it will be improper, unethical, for you to seek to represent two accused persons whose interests may conflict during the trial. The evidence that is coming against them, those evidence are coming individually, even though the prosecution may have shot one bullet of evidence against them. When you split it, you find that the facts as pertains to the evidence, they individually affect them differently. So as a lawyer, if you are standing there, which of the accused persons are you going to defend with the kind of evidence that has come? and which of them is going to be disadvantaged if you use the evidence to defend, let's say, accused A.
So in a situation where you don't know ahead of time and a group of people are in trouble and all of them come to you and say, lawyer, we all want you to represent us. Then you start and you discover that the information for one client, if used, may go against the other. What will you do?
You see, the profession is an honorable profession. You must be honest to yourself and to your profession and to the clients you represent. As soon as you see such an event, you have to act timeously as a lawyer. You have to disengage your services, and you must give reasons for doing so. So for me, time is of the essence to some of these things.
So if you didn't anticipate it and somehow it came up and then the case ended and there are 5 people and then maybe 3 were acquitted and 2, have been found guilty and jailed, and they take an issue that you didn't do a good job, can you be punished for that?
You see, the law has always, let's say, the law can be visited upon you for an infraction, but the law itself also gives defenses. The fact that we have the rules governing the profession doesn't mean that as soon as the rule is invoked, a lawyer is presumed guilty. I mean, we have presumption of innocence.
Right.
All these things are there. And if it's a contract, as I said, then there must be defenses. The lawyer should be able to explain himself. If he has good reasons why he did that, knowledge is also important. In the profession, knowledge of certain matters ought to be imputed to you as a lawyer.
All right.
Okay, and if those knowledge matters are imputed to you, then you may not have a defense.
All right.
But there could be legitimate.
Let's go to you now, and
defenses.
we'll return to 3 others of the rules that you are interested in looking at, including Rule 19, which is confidentiality of information. Confidentiality of information. Yes. Which of the rules among those that we have listed that you think is very important to look at?
Well, I mean, incidentally, we may agree on confidentiality because it's quite controversial. Okay, so if a client, and I had some serious engagement with my students, especially, I teach at post-course, some of whom have been trained
and that
elsewhere.
rule says a lawyer shall not reveal information relating to the representation of a client unless, so there are exceptions. Okay.
So apart from those exceptions in the rules, there are exceptions in substantive law, like the Evidence Act and so on. So that then if a client tells me that, this is the money I want to pay you for a business I did, but I robbed someone, and so as a lawyer, what do? Are you supposed to now go to the court and tell the court that my client here has committed an offense, or are you going to the police to tell the police that my client has committed an offense? Because a competing responsibility on you also is to, as much as possible, keep information that your client has confided in you and not to disclose it without his consent or approval. And so these major competing interests, for me, I think is one of the most onerous burdens
this is very important to you because you mentioned this the last time.
Yes, onerous duty that is imposed on a lawyer. The fact that there is a rule.
So when does it become misconduct according to the rules?
So there have been many cases. I mean, if you talk about the cases on Abna Pokuya, which we are familiar with, you talk about Kubaji. In these cases, the court is even not very specific on what to disclose. But it appears that if it concerns
the commission of a crime, Article 18 of the Constitution has specifically given some exceptions to when information, yes, can be used even in a case. And so in that case, it doesn't matter whether you are the lawyer. Once it comes to your information, it comes to your knowledge, and you know that without the disclosure, the accused person will either complete the process of commission of the offense, or you'll be able to prevent him from committing the offense. Then you have a duty. Article 41 also imposes a duty on all of us to combat crime and wastage of state properties and so on. So, as a lawyer, once this comes into, and I think that in all fairness, you should tell your client that, look, you have committed an offense. You have to tell the appropriate agencies of state.
So the law says you should not reveal that the information that your client gives to you. That is general. Then it comes to make a certain exception.
Yes.
It says that you may reveal the information if it is necessary to prevent reasonably certain death or substantial bodily harm, to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another person, and in furtherance of which the client has used or is using the services of the lawyer, to prevent, mitigate, or rectify substantial injury to the financial interest or property of another person, etc., etc.
Yeah, so some say these are, as Lawyer Ahmed said, these are some of the provisions that make the legal profession a unique one. I mean, we don't hold brief for anybody, but this is one of the things that your client has, to use the ordinary word, confided in you. The rule says that you cannot disclose it unless he approves of it. At the same time, as a lawyer, you also have a duty to prevent the commission of a crime, or when it has started, to ensure that it doesn't get to the completion stage.
Okay.
Or when the information comes to your knowledge, it is your duty to either compel the client to report it to the appropriate state institutions, or then you do so yourself. And that is why the exception rather becomes a rule in this case, so that you don't say, oh, well, it's just an exception. Now, let me just sit by and let him go away. You still have a duty as a citizen of Ghana to disclose the imminent commission of a crime, whether it's by your client or not.
Okay.
I actually wanted to ask my brother a question on that.
Very quickly.
Let's say we have this situation of witness statement. You have obtained documents from a client, and you file the documents before the court. And then the client comes to tell you, look, lawyer, I didn't ask you to file these documents. They are supposed to be confidential. Why did you expose it to the court? Would such a situation amount to breach of your...
Well, I mean, if you know, at the same time, we have a duty, especially with state attorneys, you have a duty to disclose information that will lead to the acquittal of the accused person. And if you don't, it can even lead to the state paying compensation, and or you even losing your. So, and at the same time, conversely, for an ordinary lawyer, I think that you still have a duty to disclose that information that can lead to the
client has the right to dispense with you.
Yes.
Go and get somebody else who will do it that way for him. Yes, and you are interested again in Rule 13, which is communication with represented person. A lawyer shall not approach, communicate, or deal with a represented person on another matter, or even attempt to negotiate or compromise a matter directly with a represented person, except through or with the consent of the lawyer of that represented person. What does that mean?
You know, this, as I keep saying, Our profession is an honorable profession, and it is based on reputation, integrity, respect for the law to your profession and colleagues. Now, what it means is that you are representing a party in the case. Now, there's another lawyer also representing another party in the case. The rule seeks to say that because you are both coming from different angles, you are representing parties, two opposing parties, if you like. It should be unethical for you, one lawyer representing Party A, to speak to Party B on the issue pending before the court, or which is the subject matter of the legal transaction, to seek to speak to that party when he's represented by a lawyer without a lawyer's consent. I think
so. You can only talk to them if you are representing your client and they don't have a lawyer and they still want you to talk to them.
Even that one, it is not even allowed.
Even that
it's not allowed.
No.
It's not allowed.
But some of them do it.
They do it.
They say, lawyer, I don't have a lawyer. I can't afford one.
But it is wrong.
But I want us to...
It is actually wrong.
In situations where they have lawyers, they would find a way to reach out to you.
Without the knowledge of their lawyers.
Without the knowledge of their lawyers.
And the law doesn't allow that.
It doesn't allow that.
But that is why I say that we need to have a holistic view about these rules. The society in which we live, I mean, in Ahimfie, where we are familiar with, this person can go to Lawyer Ahmed as Jantuahini. Another person can come to the same person as Jantuahini, and they see nothing wrong with it because, in their view, this is someone who is known in the society to have the proficiency and the skill to resolve matters. So it doesn't matter if both of us go to him to help us resolve the conflict between us. We have not been able to fashion out rules that reflect some of these. And it's difficult for even a client you are acting against to understand that he can't even call you. I'm very sure that if you call 10 lawyers right now, 8 of them can tell you that the opposing client would have called him, lawyer, I want us to solve this problem. What can we do? I don't want my lawyer to even know that I have called you. So these rules, I keep saying, should be looked at holistically.
The same people could bring you into trouble by reporting you to the general.
Oh, yes.
Of course. So you direct them back to their lawyer.
Yes.
You can only talk to them through their lawyer.
Yes.
That is what you do.
That should be the
Thank
case.
you very much. Time is running. We give you the opportunity to call us now. You can call and ask questions on the issues that we are discussing right now. So you can call. The numbers are as advertised on your screens. And let's now look at section 36, is it? Which is of interest, Regulation 36. Regulation 36 is about fairness to opposing party and counsel.
Yeah.
Yes, a lawyer shall not unlawfully obstruct the access of another party to evidence or unlawfully alter, destroy, or conceal a document or other material that has potential evidential value. So, I'll mention that last and spend some time around it. What is it about this particular rule?
Being fair to your colleague. I think this to me is not a novel, or it's not something that is new. In the profession, we have thrived on respect. You know, we are all lawyers. So the respect you accord to your colleague will also return back to you the same way. It won't be unfair for you to seek to undermine your colleague in the performance of his functions as a lawyer. That to me is very essential. And that to me is the underpinning reason for this rule. Respect. There has to be mutuality of respect so that you help me, I help you.
How is the fairness to the opposing party manifested?
Yeah, so you see that again, there's this competing interest as well.
Again, yeah.
Yes, because at the same time, you are to vigorously push the case of your client, as it were. And yet, when information comes to your knowledge, it is your duty to inform the lawyer on the other side. That is what my client is saying. Even where that information will be against your own client. When the rules say that, do your best to push the case of your client. However, when there's information that you have received, and that will rather even support the case of the opponent as much as possible, you should disclose that. And that is why I say that it makes the legal...
Why would I be doing that?
Yes, but, but that is why it makes the legal profession very unique, because it is more, it is pastoral. It's about a call to duty to God himself.
But people know generally that the life of a lawyer and that of a priest is completely different. They are completely different.
It has never been the case.
But I think that rule is actually hinged on the fact that when you appear before a court, you must provide all necessary evidence to the court. That is why this rule...
Even when it's against your client.
Yes. You see, I mean, it's not simply saying disclose the information to the other lawyer. If you disclose to him, is he the one going to resolve the dispute?
Okay.
So the target is the court. Disclose the information, and by so doing, you are fair to your colleague.
Let's quickly look at 48 and 49. And 48, unauthorized practice of law. Yeah, I would be so interested in this, training lawyers in the law school. And then appointment by a court. So, unauthorized practice of law. Yes. What is that?
Well, so
okay, I'm looking at it from 3 angles.
Okay.
The first is a lawyer who has been called to the bar, and he's on the roll of lawyers. He cannot practice if he doesn't have solicitor's license. That is one.
And that license is acquired every year?
Every year.
Okay.
So
people have lost their cases because the lawyer didn't have a license.
It's additional to the requirement to practice law.
Okay.
If you like.
Right.
The second aspect is a lawyer who has obtained his license in any common law jurisdiction, but not in Ghana. And he's now in Ghana as a Ghanaian or non-Ghanaian, but he cannot practice. The reason being that he has not undertaken courses in legal systems, customary law, family law, and so forth. I know these are conditions. So that's the second category. And I know there's a case, is it Ashley? Ashley or something?
Hold on. How do I'm going to a lawyer, how do I know this lawyer has a license? People have gone to court, gotten a judgment, only for the judgment to be annulled because their lawyer didn't have a license.
Yes, so, I mean, we know there's a famous case to that. And the minority in that case at the Supreme Court actually argue that, look, in the society that we live in, it's very difficult for you to find out whether this lawyer has a license or not. But then the majority decision, that's those who were more for it, said that, well, look, for a ruling, interlocutory application, if you want to appeal against it, it's 3 weeks. If your lawyer, or 21 days, if your lawyer fails to file it within the 21 days, not only will the lawyer then must have contravened the rules, but you, the client, will lose. And there will be no opportunity for you. So clients...
Who is on the line? Let's hear you quickly. These days, you can just type the lawyer's name into Google. Just say lawyers in good standing. It will take you to our site.
Actually, we are required to disclose to them.
Yes. Okay, hello.
We are required to disclose.
Awudu. You're calling us from Navrongo. Quickly, what's your question?
Oh, wow. It's Awudu.
What's your question?
Please, the question is with regard to the undercharge of the fees. Assuming you, Samson, you have a brother who has a case, but is unable to raise the amount of money that a lawyer may charge, and he has a case in court, can you, as a brother or a relative, lower down the fees for the person.
All right.
Would that amount to
underestimation of fees? Thank you very much. I think you addressed it. So the answer remains what the two of you had already said about that.
That we take into
right.
account. Yeah.
So we were talking about the issue of not having a license and not knowing.
Yeah. So yes, that's you see the Bar Association now publishes what they call lawyers in financial standing. First, it used to be
in good standing.
Now it's financial standing. That may not be conclusive of whether or not the lawyer has renewed his license, but it is our duty. That is why if you ignore the requirement and still act for the person, there's even a criminal element of it. You can even be convicted for committing a crime as a lawyer. So apart from the fact that your client's case may be dismissed because you as the lawyer didn't have the license. You see, when you are called to the bar, you are given a license.
That's right.
As a lawyer.
Right.
But every year, like the driver's license, I think it's 2 years.
I'll pick this
You
call.
must renew it.
I'll pick this call, and when I come, somebody is asking, bottom line, what should I do if I want to report a lawyer on any of the issues you have spoken about, which I think my lawyer has aired? What should I do? How do they do it? Quickly, you will help us to know that. Hi, you are calling us from Tamale, is it? Yes, you are calling us from Adabraka.
Awesome.
What's your name? What's your question?
My question is concerning beside the legal fee. Beside the legal fee, after a lawyer appears at the court, you have to give him something to as a transportation. So is all this part of the legal fee? I want to know. Because
Okay, it's transportation for a lawyer part of the legal fees. It depends on how you have arranged your fees with a client, isn't it? If you have arranged it that you'll be paying for transport, then that's part of it.
Something. The difficulty is that sometimes you are around the court, you meet someone, oh, please, can you just represent me in court? You don't have an agreement with the person. So you get bail for him. And then you send the bill, and it becomes a problem. It's all because we substantially live in an informal community or society.
Okay.
So
because of time,
okay.
What does anybody do if they want to report misconduct?
Well, if they want to report misconduct, there are avenues. And I think that the first place is to look for a lawyer and ask him whether or not what his experience with another lawyer entitles him.
Too many lawyers may not want to represent somebody who is going to deal with another lawyer.
Oh, well,
so what do they do?
They can simply go
online.
Yes, they can go online.
Yeah.
Then there is the governing body or the supervisory body is the General Legal Counsel. And I'm sure when they go to their website, the guidelines are available to guide them as to what to do.
So I can tell you straight away, if you simply Google General Legal Counsel, you see what will come up. And on their platform, there are forms. You can actually lodge the complaint electronically.
But I think that...
And you can also type it out if you understand it, the way you do.
But something, I think that because it's a contract
at their place.
It's always better to go to the lawyer.
Why are you running away from people reporting where they are supposed to report?
I'm not at all. I'm the last person to do that. Okay. But it's always important because when there's even breach of contract, there's negotiation. It's always important to go to your lawyer.
Some of the legal contract, the fee agreement may have in it a provision for
breach of contract and what
arbitration,
what
negotiation. They will have all those things.
So it's always important to go. You have breached this part of your promise or your contract. So these are the rules. What do you want to do about it? Are you prepared to now make
amends?
If
you are not satisfied, then you can.
Yes,
but to proceed,
so that as soon as there is breach, then you go to the final stage.
But majority of the clients too become malicious. As we can say, most of our colleagues also undermine the reputation of the profession.
Okay, my guests have been Berima Yao Kodie Opong, who is director the Ghana School of Law and director of legal education in Ghana. Musa Ahmed is head Ahmed Legal Consult. We can't thank you enough, gentlemen, for once again making time to be with us and helping not only the client but also lawyers. Have a good afternoon. This has been The Law. It's your legal light. It's your health law. I'm Samson Ladia Yanini.